Original and appellate jurisdiction of the Supreme Court. Original jurisdiction. The Supreme Court has original jurisdiction over cases affecting ambassadors, other public ministers, and consuls. Petitions for certiorari, prohibition, mandamus against the Court of Appeals, COMELEC, the Commission on Audit, the Court of Tax Appeals, and Sandigan Bayan. The Supreme Court has concurrent original jurisdiction with the Court of Appeals in petitions for certiorari, prohibition, and mandamus against the Regional Trial Court, the Civil Service Commission, the Central Board of Assessment Appeals, the NLRC, quasi-judicial agencies, and writ of kalikasan, all subject to the doctrine of hierarchy of courts. The Supreme Court has concurrent original jurisdiction with the Court of Appeals and the Regional Trial Courts in petitions for certiorari, prohibition, and mandamus against lower courts and bodies, and in petitions for quo warranto and writs of habeas corpus, all subject to the doctrine of hierarchy of courts. The Supreme Court has concurrent original jurisdiction with the Court of Appeals, the Regional Courts, and the Sandigan Bayan for petitions for writs of amparo and habeas data. The Supreme Court has concurrent original jurisdiction with the Regional Trial Court in cases affecting ambassadors, public ministers, and consuls. How about appellate jurisdiction? The Supreme Court has appellate jurisdiction by way of petition for review on certiorari or appeal by certiorari under Rule 45 against the Court of Appeals, the Court of Tax Appeals en banc, Sandigan Bayan, against the RTC on pure questions of law, and in cases involving the constitutionality or validity of a law or treaty, international or executive agreement, law, presidential decree, proclamation, order, instruction, ordinance, or regulation, the legality of a tax, imposed assessment, toll, or penalty, the jurisdiction of a lower court, and the Court of Tax Appeals decisions rendered en banc. The general rule is that the Supreme Court may not pass upon issues that are factual or factual issues. However, there are exceptions in which factual issues may be passed upon by the Supreme Court. These include when the findings are grounded entirely on speculation, surmises, or conjectures. When the inference made is manifestly mistaken, absurd, or impossible. When there is grave abuse of discretion. When the judgment is based on misapprehension of facts. When the findings of facts are conflicting. Also, when in making its findings, the Court of Appeals went beyond the issue of the case, or its findings are contrary to the admissions of both the appellant and the appellee, or when the findings are contrary to the trial court. Also considered as exceptions in which factual issues may be considered or passed upon by the Supreme Court are when the findings are conclusions without citation of specific evidence on which they are based. When the facts set forth in the petition as well as in the petitioner's main and reply briefs are not disputed by the respondent. When the findings of fact are premised on the supposed absence of evidence and contradicted by the evidence on record, and when the Court of Appeals manifestly overlooked certain relevant facts not disputed by the parties, which, if properly considered, could justify a different conclusion. How about the constitutionality of law? Lower courts have jurisdiction to pass upon the constitutionality of a law. However, it is prudent to defer to the higher judgment of the Supreme Court the consideration of its validity.